This employment law video is on subject access requests. An individual has a right to make a data subject access request under the General Data Protection Regulations, the GDPR. Requests. The subject access request must relate to personal data. Personal data means any information relating to an identifiable person who can be identified directly or indirectly. A request may be wide in scope, but if the request is very broad, it may be less effective. Requests are often limited to subject matters, dates, and for emails, the person receiving or sending the email, timescale. The request must be completed without undue delay and at least within 1 month. The timescale can be extended up to 2 months if the request is complex and/or the individual has made numerous requests. Any extension and the reason for the extension should be communicated in writing before the initial 1 month expires. Information supplied. The employer should provide the following: a copy of the personal data being processed. There are rules about providing data that includes information about other people. See the Information Commissioner's Office guidelines at ico.org.uk. Confirmation of the purposes of the processing. Clarify the categories of the personal data and the categories of the recipients who the personal data has been disclosed to or will be disclosed to. Information relating to the source of the data, the period for which the data will be stored, and data subjects' rights. Refusal. If a request is manifestly unfounded or excessive, an employer can refuse the request. The ICO has provided guidelines on what could be manifestly unfounded or excessive. A request could, for example, be manifestly unfounded if it was malicious with the sole purpose of disrupting the employer. An excessive request could, for instance, be where it overlaps with a previous request. There are other examples given too. If an employer refuses the request, it must give reasons to the employee. However, rather than take the risk of a dispute, the employer may be better off to answer the request insofar as a proportionate and reasonable response, but reserve their position to argue that it was manifestly unfounded or excessive if challenged. Fees. Generally, employers cannot charge a fee for a subject access request. Employers, though, are able to charge a reasonable fee for administrative costs where the request has been manifestly unfounded or excessive. Exceptions. There are a number of exceptions to providing subject access requests. Examples include: there is no obligation in relation to personal data which carries legal professional privilege. There's no obligation for a confidential reference for employment, training or educational purposes. For details of all the exceptions, see the ICO guide. That's my video on subject access requests. The usual caveat is that this video is for guidance only and should not be relied upon for specific advice. For more information, do visit my website. And if you're interested in receiving notifications on other employment law videos, do subscribe to my channel.